All right. Bainbridge Island Municipal Court is now in session. The Honorable Judge Sarah McCullough presides.
All right, good morning. Please be seated. All right, this is the matter of John Dewars versus Houston Wade, cause number 46-18. We have Mr. Wade present,
yes.
Correct? And Mr. Dewars is also present?
Yes, Your Honor.
All right, so we're here for a full order hearing related to a temporary order that was issued a couple weeks ago. Counsel, do we have any preliminary issues to discuss?
I don't know if testimony will be taken today. If it is, Mr. Moriwaki is a witness. I would ask that he not remain in the courtroom during the presentation before his testimony takes place.
Okay, so you're asking for exclusion of witnesses?
Yeah.
Okay.
Additionally, Mr. Nelson, my co-petitioner, who also obtained virtually the same TRO on October 23rd, is here to offer testimony. And this was to be subject to that as well.
All right. Okay. And any objection to the exclusion of witnesses?
No.
All right. Well, that motion will be granted. Are the parties, this is a full order hearing, and so the parties, at this point the court will be hearing testimony, considering evidence that's in the petition, and making a decision about whether or not full order can issue. Are the parties ready to go forward with that today?
Yes, sir.
Okay. And so I did receive some briefing in this matter. I received a brief that was filed today by Mr. Dewars, but this said that it was requesting a TRO extension hearing.
I think that's just probably imprecise nomenclature. What I mean to offer that brief in support of it is the
full order.
Full order.
Okay. And did you receive a copy of this brief?
Yes.
Okay, but just before the hearing?
Yeah.
All right. And then there was some other paperwork that was also filed. I'm not sure who filed it, but it was basically the matter involving Clarence Moriwaki and Richard Rynearson, 17-2-014631, decision on Ralge appeal, as well as a federal case, defendant's motion to dismiss in opposition to plaintiff's renewed motion for preliminary injunction. This is cause number 317 CV 05531 RBL. And so these were filed in this matter by somebody. Did either of you file these?
No.
Your Honor, what I sent you in addition to the supplemental legal memorandum today was a copy of the Kentucky County Superior Court's appeal decision vacating the injunction in favor of Mr. Moriwaki, as well as the brief of the Attorney General's office offered in opposition to Mr. Rynearson's renewed motion for a preliminary injunction against nominal defendant Ferguson in his federal court action before Judge Layton to invalidate the Washington cyberstalking statute based on being facially unconstitutional.
All right, thank you. Well, I have not read this motion before, but I have read the decision on Ralge appeal and am familiar with the case law and the decision itself. And was there any other information that was going to be filed by any party today?
Probably all of this.
Okay.
Yeah.
All right, so you're going to be offering some testimony?
Yes.
Okay.
Lots of it.
And before we move forward with that, the court did grant an exclusion of witnesses, so Mr. Nelson can wait in the hall until he's called.
Okay. How long do you expect this to? Hour or two?
Don't know.
Okay. Thank you.
All right. So in a protection order hearing, the rules of evidence don't apply. So it's not the same as a full trial where we have to apply the evidence rules. Typically people represent themselves, as is the case here, and the court will allow testimony in a more narrative fashion, and the rules are relaxed in terms of establishing some of the foundational requirements for admitting evidence. I tend to, as far as time goes, tend to admit things and then to review them and exclude them if they, and disregard them if they really aren't relevant. But I certainly can hear argument on objections to pieces of evidence as they come up as well. Now, it looks like you have a number of documents that are laid out all over your desk.
Yes.
Did you provide copies of those to Mr. Dewars?
He has access, I believe, to all of these things. I can make copies for him if he needs them.
What do you mean he has access to them?
Most of them is his words and screenshots that he was already provided.
Okay.
Yeah, or at
Okay.
least some in limited context.
Okay. And so the court does have the original petition that has been filed and any documents that have been attached to that, as well as the briefing that I mentioned here. So we don't need to, I certainly am willing to hear context around that and additional testimony if you think that that's helpful to the court, but I also we don't have to readmit the same things that are admitted here, if that makes sense. So in a proceeding like this, the petitioner bears the burden of proof, and so Mr. Dewars is the petitioner here, and so he will be the person who goes first, and he can provide his own testimony if he would like. He can call witnesses, he can offer documents, and I will do that first. And then once he has concluded his case, if you would like to testify and present evidence, call witnesses, you may do so. And, I would hope that we can conclude this matter this afternoon. I guess I'll just have to see what it is that you all would like the court to know.
Okay.
And then once you are done with your side, you'll certainly have an opportunity for rebuttal, and you will have an opportunity to rebut any new information that is there, and I will hear some brief closing arguments if you wish to make them, but you're not required to make them. So any questions about how we are proceeding today?
My only question would be, is it the case that the person who was just entered the courtroom is Ms. Cassie Stokes from the prosecutor's office?
I believe so, yes. And nobody's planning on calling her as a witness? So there's...
I may. No, then I will not.
Okay. All right. So Ms. Stokes then is not going to be excluded from the courtroom, and we will begin. So, Mr. Dewars, do you plan to present testimony here today?
Just my own and Mr. Nelson's.
All right, so please raise your right hand. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
All right. So please state your full name for the record.
John David Dewars.
All right, and Mr. Dewars, what is it that you want the court to know about your petition for a protection order for both harassment and stalking?
I don't want to reiterate too much of what is already in the original petition. Obviously, our earlier hearing with Judge Carruthers afforded more time to dig into that. If Your Honor has questions about the factual foundations, I'll take the lead from Your Honor and the questions.
Well, it's your case, so if you have further testimony about these, the context of these, or information that you want me to consider, then now's the time to provide that.
For sure. By way of context, I don't recall ever having met Mr. Wade. I'm going through a very contentious divorce. My wife and I separated in January of 2017 when she was arrested for domestic violence, not me. She sought, after her release from jail, I'm sorry, January 2017, not January 17, she sought, after her release from jail, a domestic violence restraining order, which she voluntarily abandoned. She brought another one in the middle of the year, which she voluntarily abandoned. And she brought another one in late 2017, which was ruled on January 10th, 2018, the court denied her application, found there was no basis for domestic violence of any kind, and set preliminary custody orders and spousal maintenance orders and child support orders that afforded me 50% custody of the children. And since then, things have been going along pretty calmly for the most part. But I believe that my wife's relationship with a few friends has provoked, in particular, Mr. Wade to feel as though he should champion her interests now, almost 2 years later, by, to use his own words, destroy my life, take away my livelihood, which is something that he's done on his own Twitter page, his own Facebook page, and a Facebook page he created called the Bainbridge Island Bad List, where I and Mr. Nelson were listed. Mr. Nelson was accused for rape, which I understand has been later forgotten.
How do you know that Mr. Wade is the creator of the Bainbridge Island Bad List?
So he will testify that today. Officer Weiss from the Bainbridge Island Police Department interviewed Mr. Wade to ask him about the bad list, and Mr. Wade told him, it's in the police report, that he was the sole creator of the Bainbridge Island bad list. Additionally, I have exhibits demonstrating that Mr. Wade refers to himself in Twitter posts as the Bainbridge Island Bad List, and Facebook posts as the Bainbridge Island Bad List. And that I am suing both the Bad List and him for defamation.
Now, is there a defamation suit that's been filed?
Not that it commenced.
Okay.
He has until Saturday.
Well, I'm going to hear from you, but so tell me about that. I did see some information in here that was about the possible defamation suit to be heard at ex parte in Superior Court, but did that not occur?
We elected to proceed with this course of remedy for now.
Okay.
Not proceed with the defamation suit.
Okay.
Mr. Wade sent messages to my coworkers, to my employees, to my law partners. The exhibits are here. He states that his desire...
Are you referencing the original petition?
Yeah, it's on the original petition, so I only want to gloss over it.
Well, let's talk specifically, though, about what it is, because I think that I have a message that was sent to, I believe, your law partner. Is that correct?
Sure. Just walking through on page 5 of the original petition is one of the posts from the Bainbridge Island Bad List. What it doesn't contain is...
We're referencing Exhibit A?
Yeah, hundreds of comments, including comments by Mr. Wade, that are offensive and defamatory. It's been causing tremendous professional and social problems in my life, as well as severe emotional distress.
Okay, and then is Exhibit A, it looks like on top it says the Bainbridge Island Bad List. This is the post that's on the Bainbridge Island Bad List?
It's one of the couple of posts that I think were updated by Mr. Wade throughout this period. There are several other people identified on the so-called bad list, including there was Mr. Nelson until October 23rd.
And so tell me what it is that you see as the issue with this post.
He's an abusive alcoholic. No, I'm not. He commits domestic violence. No, I haven't. He's been charged multiple times for obstructing law enforcement. No, I haven't. He claims to represent clients he is not. No, I haven't. He's banned from several local restaurants. No, I'm not. He exhibits drunken and belligerent behavior. No, I haven't and I don't. He spent his marriage trying to have sex with women using internet dating sites like Tinder and seeking arrangements. No, I didn't. John is currently going through a contested divorce where, despite a no-contact order, there's no no-contact order. Until I just obtained one after this post was made myself. I was bringing a motion for sanctions in the context of my divorce with my wife for her contact with Mr. Wade and others, and the court, on her stipulation, issued an order saying that we wouldn't disparage each other or otherwise undertake efforts to disrupt each other's peaceable existence.
Was there ever a no-contact order against you?
Never one other than the temporary no-contact order that this court issued in January 2017 that was voluntarily abandoned by my spouse.
Was there any portion of this post that's true?
I pled guilty to hit and run.
That's the only portion of it that's true?
Yes.
All right.
Going through, there's another post on his own Facebook page on page 8. He's surveilling me, asking for information, and this is disseminated to thousands of clients and friends of mine.
How?
Mr. Wade's distribution list, both on the Bainbridge Island Bat list and on his own webpage, includes thousands of people and hundreds of locals that are social friends and clients of my law firm and professional colleagues of my law firm as well. They see Houston's own posts. And
Because they're friends with him on Facebook?
And then they come up on my post if my name is tagged in any of those posts.
Mm-hmm.
And so I've been getting contact from people internationally.
Okay, but tell me about this Facebook page. What is required for someone to receive information about it?
Well, it appears on my own Facebook feed if anybody mentions me on it, and then it is advertised and discussed throughout the various Bainbridge community groups, including Bainbridge Islanders, and is discussed on Houston Wade's Facebook page and his Twitter pages. So links are directed to the backlist page.
All right, well, let me ask you this. Don't you control the settings on whether or not if someone is allowed to tag you using your name on a Facebook page?
I may be able to, but what is the primary issue is the local community that Mr. Wade is attracting to the Facebook page, and then the information that he's reposting on his own Facebook page with links going back to it and replicated identical information, as well as on his own Twitter pages.
Mm-hmm. Okay, go ahead.
The primary takeaway, so he's emailing my law partner Derek Newman, my law partner Jessica Newman. He's emailing Eileen Sorrells, one of our paralegals.
Well, now I just have, let's reference them specifically. So there's Exhibit C, that's an email that went to info@newmanlaw.com. Is that what you're talking about?
Yes, that is part of it.
And
that
then
distributes to our paralegals.
Okay.
It's on page 13, Exhibit D. At the top, you see Eileen Sorrells, my secretary, one of my secretaries, is receiving this communication from Mr. Wade.
Well, it looks like that communication in Exhibit D is a review on Google My Business. Is that correct?
Correct. And we just hired a new receptionist who was Googling our law firm to get our address for a lunch delivery, who said that she discovered Mr. Wade's post on the Google reviews as well.
Okay, well, let's talk about this. So it says partner John Dewars has a lengthy criminal record, including imprisonment of a minor, domestic violence against his wife, hit and run, and multiple charges for obstructing a public officer. He will threaten suit against anyone who lets it be known that he is an abusive alcoholic. How he still has a license to practice law is beyond me. So tell me what about that is not true.
Which exhibit are you looking at?
I'm looking at Exhibit D filed. It says I'm reading the Google My Business review from Houston Wade with a named person. I'm looking at the email that was sent to. It was an email that was sent to Eileen Sorrells from this Google My Business. It says in the subject line, Houston left a review for Newman Dewars LLP on Google My Business.
Having a lengthy criminal record of domestic violence against my wife is a mischaracterization. Multiple charges for obstructing a public officer is not true. He will threaten to sue anyone who lets it know that he's an abusive alcoholic. That's not true, and I'm not one. How he has a license to practice law is beyond me. The thing that I would pause for a minute on...
But is it true that you have a conviction for imprisonment of a minor and domestic
In
violence?
2012.
So yes, is that...
Right.
Okay, and what about domestic violence conviction?
That's the same thing.
Okay, so yes, that's correct?
Correct.
Okay. And it's correct that you have a conviction for hit and run,
Correct.
but you don't have a conviction for obstructing a public officer?
No.
Okay. But were you ever charged with that?
I don't think so.
Okay.
Here's the thing that I think Your Honor should focus on, because I think this is the proper analysis. Judge Carruthers came away from the October 2013 finding that the conduct fit the definitions of harassment and cyberstalking. And we can go through the plain language definitions of those two statutes. Your Honor's line of questioning seems to focus on the defamatory quality of the posts.
That's correct.
And the overwhelming case law says that defamation is a completely separate question from harassment and cyberstalking under the Washington statutes as well as the federal cyberstalking statute.
Well, before you go into that, doesn't RCW 1014-020 indicate that the course of conduct does not include constitutionally protected free speech?
It does.
And is true statements defamatory free speech? Defamatory language?
Defamatory language is one of the many kinds of unprotected non-free speech. There are several kinds. The statutes in Washington for cyberstalking and harassment deal with another kind, specifically under the Giving Doctrine. Defamation would be a whole other conversation. Free speech that's otherwise protected because it's true or because it's opinion or because it's hyperbole becomes unprotected for purposes of the Washington cyberstalking and anti-harassment statutes as well as the federal anti-harassment statute when it's coupled with particularized conduct that fits the plain language definitions of the conduct prescribed by those statutes. Every court looking at this issue has found that it's an entirely distinct question from defamation. So the research in front of Your Honor in the supplemental briefing that I supplied represents a review of every single federal case dealing with the First Amendment intersection with the federal cyberstalking statute, and every case in Washington dealing with our Washington cyberstalking statute at all, and every case in Washington dealing with harassment where there are First Amendment implications either in a restraining order setting or in a criminal prosecution setting because
well, why don't we, before we get into legal argument, why don't we finish going through what the facts of this are and what happened. So you were talking about what it is that he did
Yes.
to constitute harassment and stalking.
So it's Facebook posts, Twitter posts, his own Facebook posts, the Bainbridge Island Municipal Facebook posts, the hundreds of comments under those Facebook posts, and including the discourse, which I couldn't fit onto these pages.
Did you bring those for admission to the court record?
No, they were taken down by Mr. Wade after the restraining order.
Okay. All right. And so there was conversation that went on between Mr. Wade and other people after this was posted. Is that what you're trying to say?
Correct.
And other people said negative things about you?
Yes, largely in response to Mr. Wade's criticisms.
Okay.
And it's resulted in social dissociation. It's resulted in dissociation from friendships with the parents of my children's schoolmates. resulting in lack of access to a healthy social environment for them. Mr. Wade's stated intent is to destroy my life, and he's pursuing that very aggressively. I believe the case law properly places the inquiry not on the defamation analysis. I know that Mr. Wade hopes that the case will only be about defamation, so that, as he states here, and I guess I'll offer this into omission, in an online exchange on the Bainbridge Island bad list. May I approach him?
Yes, why don't you show it, hand it to the officer. So is that a copy for him?
Yes.
Okay. Or you can come, that's fine. I'll have the officer bring it up.
I have this.
Okay, so you're offering this as an exhibit?
Yes, Your Honor.
Any objection?
No.
Okay. So this will be marked and admitted as Plaintiff's Exhibit 1.
These bear on the question of intent, which is core to the First Amendment analysis for the cyberstalking and anti-harassment statutes. At the top he says, we look forward into creating dozens of corroborating character witnesses showing just what a horrible liar and abusive person you are should be memorable. And the question that you'll see raised in the case law, Your Honor, is whether or not that appears to be First Amendment protected social commentary, or by preponderance of the evidence more geared toward harassment, tormenting, or embarrassment, where defamation under the case law has no part of the analysis. At the same, when I asked him to tell me who he was so that I could pursue legal recourse, he just said, we're going to go to the Bar Association, you're going to have to juggle your divorce, a harassment suit against your wife, or countersuit, an investigation by the Bar Association, and you're going to sue us. Sounds like you've got a full docket there, Chief. He says, I like having you do it the expensive way at the top of that last comment. In other words, I have to send a subpoena in order to find out who's sending the messages. He, on page 19, he says to me, you will lose your law license in the coming year. Drunk moron. I'm going to ruin you. It's going to be so much fun. When we do get to the case law that governs all this, Your Honor, those kinds of comments, I'm going to ruin you and it's so much fun, are the exact intent or mens rea that the courts at the federal and state level are looking at to determine whether or not speech has remained pure, protected First Amendment speech, or whether its combination with conduct has elevated it to the proper subject of the anti-harassment and cyberstalking statutes.
Okay, well, I'll ask you later if you can point me to the citation where it tells me that I don't look at the First Amendment if the intent is negative.
Yeah, absolutely. And it's not that you don't look at the First Amendment, it's this. And this is the analysis. I'll try and state it in summary form, and I'll show you all of the citations that support it.
Okay, but let's continue to talk about the facts that you are presenting here. So if you have additional facts that aren't in your petition, let's get to those.
Additional facts that aren't in my petition. I don't have additional facts that aren't in my petition, except that Mr. Wade has continued to violate the orders since October 23rd. He emailed me in violation of the no contact principle component of the temporary restraining order. He left derogatory posts up on his Twitter page. He left derogatory posts about Mr. Nelson up on his own Facebook page. He left the Google review site up on his Facebook page. And on October 29th, he came into a restaurant where I was dining with a friend, walked past me, gave me clear evidence that he knew I was there. My Jeep was parked out front. He knows what my Jeep looks like. He winked at me. He waved at me. He walked to the bartender next to me and said, do you know if John Wars has ever been 86th from this establishment? And I told Wade to leave. I told Mr. Wade to leave, and he gave me the finger on his way out the door.
Okay. And so is that all that you have to present for your testimony?
Other than Mr. Nelson, but I'd rather spend my time on the law.
Well, is Mr. Nelson a fact witness for your situation?
For the posting on the Bainbridge Island bad list and the course of conduct in making those posts, which is relevant both to intent and the actus reus elements under both the cyberstalking and anti-harassment statutes. It's part of the
Okay.
context.
Well, but this is their opportunity to present facts. So if you want to call him as a witness, this is the time. Okay. So Mr. Nelson can come up. He can have a seat here at the witness chair. All right, Mr. Nelson, you can come on up here. Before you sit down, I'll have you raise your right hand. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do.
Okay, you can have a seat, please, and state your full name for the record.
William Peter Nelson.
All right, and Mr. Dewars, would you like to ask him some questions?
Yes, please, Your Honor. Does Your Honor prefer that I stand?
No, you can remain seated.
Thank you. Mr. Nelson, what do you do for work here on the island?
Construction. I'm a building contractor. I have my own business, have had for 30 years.
How long have you lived here on the island?
All my life, 59 years.
Okay. When did you first meet Houston Wade?
2001 was my first recollection of ever laying eyes on or knowing who Houston Wade is.
And how did you come to meet him?
City council race. I was running for city council against Bill Knobloch and Houston Wade. Houston at the time was 20 years old and a barista at Town and Country Market.
Okay. Did you come to become acquainted with him in the course of that city council race?
Very little, just at the coffee stand getting coffee.
What was the nature of your interactions with him?
Getting coffee. I don't recall having any conversations with Houston Wade.
Now, are you aware of blog posts made by Houston Wade in late September or early October of this year?
Painfully.
Facebook page. Okay. Between the time that you met him in that city council race and the time that you went into those blog posts, have you had any other interactions with him?
No.
Have you ever...
I should take that back. He was served at his place of work by a professional service company. I came with the professional service company to identify Mr. Wade.
But that was after the blog posts.
That's correct.
Okay. My question is, have you had dealings with Mr. Wade that would give rise to a personal dispute between the two of you?
None.
Have you spent any time with him between that city council race and the time the blog posts arose?
None.
Do you have any idea why Mr. Wade would have any ill will toward you?
It's to be investigated. I have no idea.
Okay. What blog posts were the first blog posts that you saw or were made aware of in late September or early October 2018?
It was about, I was made aware of the fact that these posts went up on October 4th, but they had been up for several weeks. I was made aware of them on, I don't have the exact date, it was Monday or Tuesday, approximately 3 weeks ago, so mid-October is when I was made aware of Mr. Houston's writings.
And how were you made aware?
Through a mutual friend.
Did you get a chance to see them?
I'm not a Facebooker, so it was brought to my attention through a mutual friend.
Did Mr. Wade make grave allegations against you in those posts?
He made extensive allegations against me that were all untrue.
What allegations did he make that were untrue?
Rape of a woman, abusing my stepchildren that evidently he felt he had knowledge of, which beyond me how he would ever have attained that, because I've never abused anyone, my children. He accused me of abusing my ex-wives. He accused me of being married 5 to 7 times. He accused me of abusing and taking advantage of my partners. He accused me of bringing outside money in from out of state for my campaign. I mean, it goes on and on and on. All untrue, unfactual, and unsubstantiated. He has no facts to the matter. He just brought these out openly to disparage and destroy my character. I've been in this community all my life. I've never done anything to anybody, including my 2 ex-wives, but treat them with kindness and love. My stepchildren, kindness and love. My generosity in the community and people I know and don't know, kindness and love. So this is completely contrary to who I am.
Did Mr. Wade's posts include any mention of the Bainbridge Island Police or the Bainbridge Island Fire Department?
Yes, it did.
What were those? What were the substance of those?
He was
posts?
associating my activities and those of the police department and the fire department with a backyard private bar that's in what's called the chicken coop, or was. There's an auto mechanic that lived there who owned the chicken coop and the auto business. He afforded me a corner of his property after my 2009 financial collapse at Linwood Center, which I was developing. And I stored equipment and lumber and supplies on one corner of his property. So Mr. Wade associated my attendance on the property as someone that was involved with the chicken coop, involved with deplorable examples of taking advantage of either underage or young women. He also accused the police department of this. He also accused the fire department of this. So everybody's included in Mr. Wade's fantasy world.
The chicken coop essentially like a clubhouse on this auto yard where the old guys get together to drink beer?
Typically it was just business and attorney, friends of his, unrelated to you or me, his friends, older gentlemen that had a boat repair business, other people that would come and have a cocktail at 4 or 5 in the afternoon and leave by 6 or so. The place sat empty as far as I recall quite a bit of the time. It was just his little backyard place for guys to hang out, have a cocktail, and enjoy the company of each other in that environment. Whatever he alludes to never went on. I never saw it. I never experienced it, and neither did the other people that could testify to the fact that that's the case.
In the online post on Facebook that started Mr. Wade's comments about you, did it include allegations by Mr. Wade that the Bainbridge Police Department used the chicken coop to drug and rape underage girls?
Yes.
Did he say the same thing about the fire department?
He alluded to the fact that the fire department was also taking advantage of girls at the chicken coop.
Did he say that you were participating in similar activities?
Yes, he did.
Was it true?
No.
Did he say that you raped a young adolescent friend of his?
Did I rape an adolescent friend?
A woman who
I've never
committed
raped
suicide?
anybody in my life.
Did he accuse you of raping a woman who later committed suicide?
He did.
Who was that woman?
Elizabeth Cartwrighter.
Was she your girlfriend?
Brief relationship with Elizabeth for a period of a few months, and it was not to be discussed about what Elizabeth's condition was, but I ended up getting restraining orders enforced against Elizabeth because at night she would call me and leave messages endlessly. I have 250 pages of transcriptions in the file in this court where the restraining orders were violated not once but twice to get her to stop calling my phone and to leave me alone. And she finally did. That was my interaction, and that was years prior to her death.
Were you ever charged with rape?
No.
You ever committed rape?
No.
Officer Weiss said Houston reported in the police report that his sole source of information about this rape was some stepfather of the young girl. Do you know who that might have been?
Jerry Denon.
Do you know anything about that?
What I knew of Jerry is he liked to sit at the Harbor Pub from about 2 to 4 every day was his routine, and then at the Treehouse Cafe from 4 to 6. I'm just approximating, but that was his normal routine, to drink and then drive home to Point White where he resided with his wife.
Mr. Dewars, do you have questions of this witness related to the harassment of you?
Did you see posts about me online?
I did.
Have you heard people talking about them?
I have.
Who have you heard talking about them?
Do I have to mention specific names?
Not if you feel uncomfortable.
I don't care to bring anyone else into it right now, but it's known in the public. It's known. He's got 1,100 followers. Word spreads on a 25,000 population base. Everybody knows everybody and knows what's going on, and bad news travels faster than good news. So the advocate of bad news has spread the word out into the community to the point where, I don't know how you feel, Mr. DeWars, but I don't feel comfortable going into a grocery store right now.
Well, no, I don't. How has Mr. Wade's all various statements about you that you characterize as harassing your petition, how have they affected you emotionally and professionally?
Devastating.
Why?
It's counterintuitive to my character. It's counterintuitive to what the majority of Bainbridge Island that knows me would say about me. It's counterintuitive to my reputation as a businessman, as a father, as a stepfather. My ex-wife would easily come in and testify right now to the fact of my credibility and my character. So this misinformation campaign that's been lodged against you, Mr. DeWars, and to me, is beyond my understanding. Fact or fiction, which 100% of what he spoke about me is fiction, created in his own mind. I can't imagine what you're going through, but you and I are sharing in this public humiliation and flogging, and I would call it a stoning. My internal mechanisms, my sense of fear, my sense of being an outcast, my sense of looking from the outside in on this going, my heart's beating right now how bad I feel about myself and you. That any of this in a sane, civil society should occur. I don't care what the internet means to you or anybody else, but if this exceeds the power of the newspaper and print, and that people can do whatever they want, and this is the wild, wild west to destroy people, count me out.
I have no further questions for this witness.
All right, Mr. Wade, would you like to ask any questions?
I would. Thank you. We've known each other since I was 4 years old, when you married my best friend's mother. So to say that you only met me in 2001.
Is there a question? You're asking questions. You're going to get a chance to provide testimony.
So yes, in 2001, when we ran for city council, and later I was out in the primary, you went on to general election. Did you ever come into Town and Country and threaten my life?
No.
Did you ever do so in front of 30 witnesses?
No.
Did you ever come in repeatedly over a course of 5 nights and threaten my life?
No.
Did Town and Country have to obtain a security guard to guard me at night because you'd come in and try to kill me?
You're fantasizing. No.
Excellent. Did you ever grope Ashley Cross?
No.
Did you do so in front of her father?
No.
Did you ever get charged with drunk driving?
I have.
Recently?
I have.
Are you an alcoholic?
That's to be decided by the treatment program that I'm in.
Okay.
Your Honor, I'm going to object on relevance grounds to the DUI. None of those are part of the posts. I don't think there's any mention.
The posts I refer to him as an alcoholic, Your Honor.
If so, then I think it's reasonable.
Have you ever used cocaine?
Years ago.
Have you ever used it recently?
No.
When was the last time you used cocaine?
In my 20s?
Really? So you were 20 years old in 1999?
I'm sorry?
Were you 20 years old in 1999?
Do you have something you're trying to drive to here?
Yes, because I witnessed you using cocaine when you showed up to a high school party March of 1999
Hey,
and then
mister,
forced
you're gonna
yourself
get-
on a 15-year-old girl.
You're going to have to substantiate that through background information.
I will. Sorry, Your Honor.
Any other questions?
No, we'll probably discuss the rest of this next week at his hearing.
All right. Any further questions, Mr. DeWars?
No, Your Honor.
All right, Mr. Nelson, you can be excused. Does this witness, any objection to him remaining in the courtroom, or are you still asking for him to be removed?
No objection, Your Honor.
I would like him to be removed, Your Honor.
All
Well,
right.
now that he's testified, I think the only basis for excluding witnesses from the courtroom is to avoid...
Subject to being recalled.
I have no intention to recall this witness, and so I don't think... I assume that Mr. Wade's case will be closed at this point.
All right. Did you intend to recall him as a witness here today?
That's yet to be determined.
I'm going to allow him to remain in the courtroom. I think he's done testifying here. I think his testimony is very of limited helpfulness of the court in Mr. DeWars' case, but I appreciate and understand why he was called. So, Mr. Nelson, you can have a seat on the bench and remain in the courtroom if you wish. All right. Any other witnesses?
No, Your Honor.
Okay. And so any other evidence that you're going to be presenting?
No, Your Honor. Just want to move on to the legal citation when it's the appropriate time.
Okay. All right. So, Mr. Wade,
Yes.
do you have testimony or witnesses that you're going to call?
I have testimony, Your Honor.
Your own testimony?
Yes.
Okay, please raise your right hand. Do you swear or affirm that the testimony you're about to provide is the truth, the whole truth, and nothing but the truth?
I do, Your Honor.
All right. Please state your full name for the record.
My name is Houston Curry Wade.
All right. And Mr. Wade, please tell the court what it is that you want me to know about this
Okay,
petition.
I wrote it out. Okay, the timeline of events in this matter is very important, and so establishing the character and habits of Mr. DeWars. Mr. DeWars is an alcoholic and drug addict, and his need to lie, gaslight, and threaten frivolous lawsuits in a vain attempt to somehow keep his criminal and unethical behavior hidden will become quite relevant as this proceeding goes on. I have little doubt that Mr. DeWars will perjure himself repeatedly during this proceeding. Mr. DeWars is an officer of the court, a licensed attorney in the state of Washington, and a prominent member of the legal community, and as such should be held at a higher standard than others.
Can you just slow down just a
Sorry,
little bit
yes.
as you're reading? Okay.
In early October, Mr. DeWars' estranged wife, Amber, having grown sick and tired of the nonstop, abusive, threatening, and belittling messages Mr. DeWars sends her daily, posted to her Facebook page several examples of said messages. Mr. DeWars' response was to threaten to sue her for harassment for posting his own harassing, abusive words. Upon my discovering of what Mr. DeWars had done and the history of abuse and violence he has inflicted upon her and their family, I took to Facebook to post my own anger over the issue. I wrote about his domestic violence convictions, hit and runs, alcoholism, etc. In my posts, I never once mentioned Mr. DeWars by name, but the islanders who read it easily identified who it was. This is because Mr. DeWars' perception of this community is downright terrible. I may even be able to use the term infamous. After an episode in a community page I administrate involving a man pursuing children and young women in Winslow, I decided what the island needs is a news source for who and where the sexual predators and abusers are and what they have done. The public has the right to know this information and is beyond relevant for a topic of journalism. Utilizing police and court records, witness testimony, and other sources of documentation, I had the first 5 irreverent reports ready to post on the Bainbridge Island bad list. I have zero interest in coddling abusers and predators. Mr. DeWars was among these first 5 reports. In my capacity as a journalist and publisher of the news page, I take this very seriously and wrote nothing that was not backed up with evidence. I have known Mr. DeWars for 15 years, and he has been awful the entire time. You see, alcoholics spend a lot of their time in restaurants and bars drinking. This means that very momentous occasions in their lives unfold in these establishments. I was there for more than one occasion when Mr. DeWars made his wife cry in public. My coworker was present when Mr. DeWars had a very public hissy fit when he discovered that his wife was pregnant. I was present when Miss DeWars discovered her husband was cheating on her. I state again, Mr. DeWars is an alcoholic and a drug addict. He has been banned permanently from multiple establishments on Bainbridge, including Brusciato, where he came to the bar heavily intoxicated, was refused service, and attempted to drive away. He would have done so, too, if dozens of patrons had not followed him out in the street and blocked his Jeep from leaving. A similar episode resulted in Mr. DeWars being 86 from San Carlos after multiple instances of him driving drunk, including a last straw where the owner called Mr. DeWars a taxi cab to pick him up after finding him slumped over the steering wheel of his car. The cab arrived, and then the driver called San Carlos to inform that DeWars got out 2 blocks away. By the time the restaurant's owner made it into the parking lot, Mr. DeWars was driving away in his vehicle.
Can I stop you for just
Yes.
a second? So are you claiming that you have firsthand, you witnessed all of these things, and that's your basis of knowledge?
Some of them and others are witness testimony from other people.
Okay.
To me. Yes.
I guess I'd raise a standing objection on hearsay grounds and lack of personal knowledge for the sake of the record, all despite the relaxed evidentiary standards.
I take it into consideration for weight, but not admissibility, so your objection's overruled, but I appreciate the comment.
All right. The owner subsequently called the police and reported the incident. Mr. DeWars has a history of drunk driving and hit and runs, including conviction from earlier this year in this very courtroom. Over a 5-month period in 2017, leading up to the hit and run July 1st of last year, for which he was convicted, Mr. DeWars was involved in 7 collisions, 5 of which he claimed were the result of someone hitting his vehicle while it was parked. Coincidentally, Mr. DeWars filed a fraudulent claim with Geico Insurance over the July 1st collision, falsely stating that his vehicle was hit while it was parked. Geico subsequently gave Mr. DeWars $29,000 for his totaled vehicle based on this false information. As you're no doubt well aware, fraud of this caliber is a felony in the state of Washington. While the July 1st incident may be DeWars' only conviction for hit and run, it certainly was not his first and probably not his last. Mr. DeWars needs to lie time and again where profoundly evident in the past several weeks. After Ms. DeWars posted spotlighting her husband's abusive messages, numerous people, of course, commented on the posting. One of these individuals who commented was Ms. Shannon Evans, then received a series of unsolicited messages from Mr. DeWars, where Mr. DeWars repeatedly made false claims that he was in fact the victim of abuse in his marriage at the hands of his wife. When Ms. Evans confronted DeWars about him being 86 from Brusciato, Mr. DeWars lied and said it never happened, and then lied again and said that he was the attorney for Brendan McGill, the owner of Brusciato. This unethical behavior by attorney shocked Ms. Evans, and she contacted Mr. McGill about the encounter and Mr. DeWars' false statements. After launching the Bainbridge Island Bad List, it took Mr. DeWars about 24 hours to discover the page, where he went on a belligerent commenting tirade, threatening to sue anyone and everyone for defamation, and again falsely claiming that he was the real victim of spousal abuse in his marriage. Ironically, Mr. DeWars posted a prime example of defamation to the Bainbridge Island Bad List, charging a man who had nothing to do with the page as being behind it, falsely stating that the man was armed and mentally unbalanced. The strange thing is, the man Mr. DeWars falsely named is a process server for the court, whom Mr. DeWars in the past threatened to shoot if he ever attempted to serve him with papers again. Mr. DeWars posted under the article, Ms. DeWars posted under the article about Mr. DeWars on the Bainbridge Island Bad List, asking that I, as the publisher, remove the post. I complied with his victim's wishes and removed the post. Friday afternoon, October 19th, Mr. DeWars served my mother with a defamation lawsuit intended for me. He also sent me a message via the Bainbridge Island Bad List informing me that he had me served. The first exchange of which Mr. DeWars included as evidence in his TRO packet is fascinating in that his initial message has a glaring and blatant lie. Mr. DeWars informed me that there would be a hearing in Superior Court in Port Orchard that Monday, October 22nd at 9 a.m. There was never a hearing. It was a lie to get me to go on a wild goose chase to Port Orchard and waste time and energy on nothing. Mr. DeWars did not officially file the suit with Superior Court. To my knowledge, still has not filed it. Our interaction via Messenger that evening, I encouraged Mr. DeWars to file the suit, as it would be an easy win in court, since the truth is the ultimate defense to a charge of defamation. Our interaction was irreverent and heated over the span of 4 hours or so, and included Mr. DeWars saying he was willing to subpoena my boss, Mr. McGill, and when I informed him that Mr. McGill would gladly testify against him, Mr. DeWars then immediately sent a message to Mr. McGill threatening him with a frivolous ADA lawsuit, all the while claiming a fictitious client he refused to name. Our conversation culminated with Mr. DeWars repeatedly sending my mother's home address to me, describing the outside of her home in detail, and then informing me that he was on his way to sodomize her. At this point, I called the police and blocked Mr. DeWars from contacting me via the Bainbridge Island Bad List. Let's be honest, the only way it is possible to defame this man is to say something nice about him. As a result, Mr. DeWars' threat of frivolous legal action, I reposted his article to the Bainbridge Island Bad List and posted to my Facebook page an update as to what is going on regarding the page and the lawsuit Mr. DeWars had served my mother. I refuse to handle domestic abusers with kid gloves and making everyone I can aware of his behavior is the absolute best tactic to take with a rich, powerful bully. I filed a complaint with the Washington State Bar Association and wrote Mr. DeWars' law firm where he's a partner, informing them of his legal threat and unethical and criminal behavior. His partner asked me to elaborate, so I did, and told him to get Mr. DeWars into rehab. Monday, the 22nd, I ignored Mr. DeWars' lie about Port Orchard. Instead, took my mother to the police station to file a report over the threat made against her, and then came here to the court to seek a protection order for her. Because Mr. DeWars only threatened her once and not multiple times, it could not be granted an order despite Mr. DeWars' violent history. I was served with the TRO we are discussing here today close to midnight Wednesday the 24th. Mr. DeWars has messaged me repeatedly via 3 different email addresses I have and via my personal page on Facebook. I have blocked him from sending me any more messages via that platform. The messages began before my being served with the TRO and continues to this day. I asked Mr. DeWars to stop threatening me, harassing me, and to refrain from further messages. He has not stopped and continues to harass and threaten me. Every instance of communication between us has been initiated by Mr. DeWars. Every single one. Mr. DeWars' history of abuse is not just physical or emotional, it's also financial. Repeatedly, Mr. DeWars will cite that all he wants to do is get on with his life and provide for his family. Yet Mr. DeWars, a multimillionaire who has not sent spousal support, child support, or even paid his kids preschool this month. After his domestic violence conviction in 2014, Ms. DeWars wanted a divorce. In an effort of good faith, Mr. DeWars offered and sold Ms. DeWars all of his interests in a startup company called Green Canopy Incorporated on August 24, 2014. This transfer of stock was intended to make Ms. DeWars financially independent should Mr. DeWars ever revert back to his abusive behavior. Mr. DeWars never gave Ms. DeWars the shares in Green Canopy, and Mr. DeWars still sits on the board of directors to this day, reaping any and all rewards and compensation for doing so. After Green Canopy's recent Series C funding, a conservative estimate for these shares Ms. DeWars never received puts their value at or around $8 to $10 million, plus whatever compensation and profits she has been denied over the past 4 years. For all intents and purposes, Ms. Amber DeWars should be an independently wealthy woman and not currently struggling to find a way to feed her 4 children and keep a roof over their head. As I said in the beginning, an officer of the court is to be held at a higher standard than the rest of the population, and time and again, Mr. DeWars has failed at this standard, and with his drunken, abusive, belligerent, unethical, dangerous, and criminal behavior. My purpose at Bainbridge Island Bad List is to warn members of our community, in particular women and children, of the men who seek to target them. Mr. DeWars' prolific use of internet sites to obtain sex and dates over the last 5 years constitutes a very real physical risk for any woman who responds to him. His behavior in person is just as repulsive, with one witness informing me that he propositioned her for sex no less than 4 times and even sexually assaulted and groped her in front of her husband at the 122. It is in the best interest of the community if these women can be warned ahead of time of the risks they would otherwise unknowingly be undertaking by accepting dates and intimate relations with Mr. DeWars. Mr. DeWars is not the victim of abuse or harassment. He is the originator of abuse and harassment, and all of his fancy legal wrangling will not change the simple fact that he is a terrible person who hurts people. That's my prepared statement, Your Honor.
All right. Do you have additional paperwork that you're offering as evidence?
I do. Mr. DeWars has perjured himself several times over the course of this proceeding. I'd like to submit as evidence. He claims that he is not a drunk, not an alcoholic, and not a drug addict. This is an email he sent to his wife August 20th, 2014, where he admits to abusing his spouse and blames his alcoholism and chemical dependencies for such.
And so why don't you hand that to the officer so he can show it to Mr. DeWars. And you obtained this how?
It was sent to me by Mr. DeWars' wife.
Okay, can you show it to him first?
Can I ask when that was sent?
August 20th, 2014. Mr. DeWars also claims that his wife abused him and committed domestic violence against him. I have emails from him from that night to his wife, who could not read them at the time because she was being detained, where he states that he does not support the charges and would ask the judge to drop them.
And
that's
you
here.
obtained that how?
From his wife as well.
All right.
And I apparently forgot to print off another set of emails where Mr. DeWars later messaged his wife, informing her that he essentially got her arrested on domestic violence charges solely to obtain mugshots and use them to blackmail her. I can send those at a later date.
Oh, Your Honor, that's just a line. I'm going to object to the admissibility on that. If he's referring to something that he's not offering into evidence and characterizing what an email says, and it is absolutely untrue, then even under a relaxed admissibility standard, I think it's totally.
Why don't we just talk about these emails first? So there's a second email by Officer Roach.
Yes.
Can you show that to Mr. DeWars? And
I also have as evidence a photograph of a contract.
I'm
Mr.
going to stop you for just a
All right.
second. So, Mr. DeWars, do you have any objection to these emails being admitted?
No.
All right, Respondents Exhibit 1 and 2 will be admitted. As for your other objection related to the talking about some emails that he didn't bring in, that certainly goes to weight and not admissibility, and your objection's noted but overruled. Okay. All right, so there's these 2 emails that have been admitted, Respondents Exhibit number 1 and 2. What else do you have?
I have a photograph of a contract Mr. DeWar signed to transfer 5,000 shares of common stock in Green Canopy Incorporated to his wife that he never actually transferred.
I'm going to deny admissibility. I'm not interested in this, what has happened between them related to money. This is just a totally not important here.
Okay.
What other information?
This is screenshots of his conversation with Ms. Evans, where he claims he was never tossed from Brusciato and that he is the attorney for Mr. Brendan McGill, which he is
Do you have
not.
a follow-up piece of evidence related from Mr. McGill?
Mr. McGill is willing to testify to the fact that
Is
he's
he
not
here?
He's not here.
Do you have any sworn declaration?
I have. One sec. Which pile is that in? I put it in. Oh, right here. This is the complete conversation Mr. McGill had with me when he announced that he was suing me for defamation. In it, threatened my mother and announced that he was suing Mr. McGill for an ADA noncompliance.
So this is the conversation that Mr. DeWars had with you?
Yes, and
Okay.
he only included the first 2 interactions where he messaged me and I messaged him back.
I believe what Mr. Wade said was that that's an exchange between Mr. Wade and Mr. McGill.
Right, but I think he misspoke. You mean that this is an exchange between you and Mr.
He
DeWars?
also messaged Mr. McGill. I have a screenshot on my phone of that message he sent to Mr.
I
McGill.
can't accept anything
Yes.
that's on your phone.
But in this conversation, he also says that he's going to be suing Mr. McGill for an ADA noncompliance when he realized that Mr. McGill would not testify on his behalf.
And so you're offering this full testimony
Yes.
because this is the full conversation that occurred as opposed to one of Mr. DeWars' exhibits,
Yeah,
which
he only
is
offered
just partial?
one. Yep.
Okay, why don't you hand that to Officer Roach. I'm going to have that stapled first.
Oh,
and then-
wait. Here's the emails Mr. DeWars sent his wife where he said he obtained her mug shots and was going to use them against her.
All right, so those will be marked as separate exhibits.
Oh, and sorry, I did print out more than I thought I did. This is Mr. McGill messaging me, informing me that Mr. DeWars had threatened him with an ADA lawsuit. Sorry, this got lost in the pile here.
Separate, I guess.
And Mr. DeWars claimed that he never used seeking arrangements. A young woman named Grace Greco messaged me with proof that Mr. DeWars contacted her to pay for sex via that website. His username is Nice Guy.
Can I see a copy?
We'll mark it as an exhibit, and then I'll mark it as for identification, and then I'll hand it to you.
What's that mark's identification for?
Because he's offering it as an exhibit, and
No, I'm sorry. What I'm saying.
we'll hand those to you to take a look at.
Okay, great.
Oh, and this is the message where he claimed he Mr. McGill's attorney and was not. This packet here is the entire conversation that Mr. DeWars and I had as the Bainbridge Island bad list underneath the posts, including the post where he claims that a man named Mr. Tyler Heineman is the creator of the Bainbridge Island bad list, says that he suffers from mental illness, is a danger to the community, and carries a gun. In that, he also claims that his wife abused him and that he is in fact the victim of abuse. And it's a very long conversation. Other people jump in as well.
What is the purpose of that long conversation to show? Why?
That Mr. DeWars is willing to lie and defame in order to, and threaten legal action in order to keep the public from knowing about his behavior.
All right, then that's the only purpose of that?
Yes.
I'm not going to admit that
Okay.
one. I don't think that's so helpful to the court.
Mr. DeWars also claimed that he was never charged with obstructing a public officer. He was charged and in this court for relating to his hit-and-run accident with that very charge, and this is also a copy of when he was charged in 2003 for that same thing in Kirkland.
All right, that will be marked. Why don't we hand, did you mark all those, Diane? Why don't we hand those, what we have so far here, to Mr. DeWars so he can take a look at those.
This is the complete posting after Mr. DeWars threatened me with legal action, and I informed my friends that he was doing so. In it contains all the comments, including multiple women who stated that Mr. DeWars contacted them while he was married for sexual relations. It's very long. Sorry.
So it's essentially everything that, the conversation that occurred on the Bainbridge Island bad list.
This one's from my own personal page.
Oh,
This is the conversation from Bainbridge Island bad list that you said you would not admit.
Oh, it's all the conversations?
Yes.
Okay, I will admit it just
Okay.
for the purposes of being complete in
This
the record
it's
as
so
to what.
thick I couldn't quite staple that one. We're warned. This original pose. This is.
I don't think that those two need to go together. I think those two are separate packets, right?
There should be. It's one packet that had a hard time stapling.
Oh, okay.
Yeah, because it was so
Okay,
thick.
Sorry.
I don't have one of those big fancy staplers. This is my original post where I did not use Mr. DeWars by name, where I expressed my anger about him being physically and emotionally abusive. In that, he is named by multiple other people as the culprit.
Mr. DeWars, don't write on those exhibits.
Oh, I'm sorry. I didn't realize these were court copies.
Yeah.
They are court copies.
sorry.
They are the originals. Don't write on them.
Sorry.
Okay. Yes. And to extend from the fact that Mr. DeWars claims he did not abuse his wife, I have multiple exchanges between his wife where he calls her awful names, says horrible things about her, talks about how she's a terrible mother and whatnot, including ones where he committed a hit-and-run accident back in 2014, and his wife is trying to get him to stop drinking and to talk to the person who he hit, and instead he calls her disloyal and says several horrible names about her. I also have other text messages where he threatens her, and text messages where he is disgruntled at not being able to find baby formula, and she informs him that there's breast milk in the freezer, and he proceeds to try and kill all of her pets.
And you obtained these how?
From his wife.
Ms. DeWars?
Yes.
All right. Officer Roach, you can take those up to have them marked.
That's all these ones, yes. And then this is just a screenshot of the Bainbridge Island bad list where it is listed on Facebook as a news page.
Okay.
Yeah.
That can be marked.
Okay.
Is there anything else?
No, I'd just like to point out that the evidence in Mr. DeWars' own words demonstrates that he committed perjury several times during his testimony, and that as a witness, he should be invalidated, Your Honor.
All right. And so do I understand it correctly that the reason that these exhibits are being offered is that you are attempting to say that this is not defamatory information that you posted?
Correct. It's not defamatory information, and his legal harassment of me began as a result of my publishing a report to the Bainbridge Island bad list, and the harassment, and every single time there's been any contact or interaction between us, has been instigated by him. And I would ask that if this does go further, that we pull video footage from Casa Rojas, where I never winked at him, never said a word to him, and never flipped him off. I did not know he was there.
Okay, well, this is the evidentiary hearing,
Yes.
so we're not going to get have time
Yes.
to gather further
Yeah.
evidence. This is the hearing.
But he perjured himself in that case as well. I went into Casa Rojas to find out if he was allowed in there in case I wanted to go there with my coworkers. It was during a time when he's not supposed to be drinking. He's court ordered not to drink within 24 hours of being with his children, and so I was not expecting him to be in there because that was within that time frame, Your Honor.
Okay. I want to give Mr. Dewars an opportunity to look through these
Yes.
exhibits before I rule on their admissibility. They have all been marked for identification. Only two that were admitted were the first two that Mr. Dewars did not object to being admitted. So what I'm going to do is those exhibits can be placed on the bar here to mark them.
Yeah.
Okay.
I'm sorry to dump that on you.
And so, and I think that there's some next to Mr. Doerr's computer there as well that were already marked.
Yeah, unfortunately, I wrote on Respondent Exhibit 9.
Okay. And so we're going to take a recess. I'm going to give Mr. Dewars an opportunity to come up here to take a look at these a little bit further. I know you may have another witness that you want to call. I'm going to excuse you to go in the hall during the
Sure.
recess. You can remain in the courtroom here to take a look at those, and we'll come back in about 10 minutes or so.
When you say about the part, that's right.
Pardon?
When you say about the part, that's right.
Yes, that's fine. Did you want to take a look at these exhibits?
Yeah, well, I think I
You feel like you had enough time?
yeah, I do.
Okay. Yeah, go ahead. So,
Oh, do you want my testimony I read as...
No.
No? Okay.
all right, so you're going to mark those and we'll give you an opportunity. We'll come back about 2:25.
All rise.
Thank you.
All rise. Court will reconvene.
All right, please be seated. All right, so we had a recess where Mr. Dewars had an opportunity to review the exhibits that have been marked. Is that correct?
Yes, Your Honor.
All right. And so Mr. Wade is offering these as exhibits in this hearing. Do you have any objections or comments related to the exhibits?
Not until it's my turn to discuss things, Your Honor.
Okay, so no objection to admission of the exhibits?
No, Your Honor.
Okay, so those exhibits will be admitted as evidence. I have not yet reviewed them, but I will do so. And that's response exhibits number 3 through
3 through 18.
Okay, 3 through 18. Those are admitted. And did you have additional testimony that you were going to present?
I have no further exhibits to present. I just want to reiterate that Mr. Dewars has been wanting to initiate contact with me every single time we've had an interaction since I posted the Bainbridge Island bad list. And I'm not sure how harassment works, but generally, if I'm the one being contacted, I'm generally not the harasser, Your Honor.
All right. And did you indicated earlier that you were going to have Mr. Moriwaki testify?
I just had Mr. Moriwaki here as a friend, emotional support to sit with me. I never had that intention to call him as a witness. So I wasn't sure if Mr. Dewars was going to.
Okay, I guess I misunderstood that you were earlier in the hearing. Is Mr. Moriwaki still here?
Yes, he's still in the hallway. Yes, Your Honor.
All right, well then he can come in. I did not understand that he was not a witness. You're not planning on calling Mr. Moriwaki?
No, Your Honor.
Okay, so he can come back in. All right, so nothing further?
No, Your Honor.
All right. Mr. Dewars, you're still under oath. Did you have additional testimony or evidence?
Before we move on to the legal part?
Before we move on to legal argument, yes.
Sure. I mean, that, to me, Mr. Wade's presentation was like something out of the Twilight Zone. It's 90% false. I'm not a drug addict. I didn't hear anything about drugs from Mr. Wade. I don't know what drugs he would be talking about. I don't take drugs at all. I rarely drink. He brought up an email in 2014 when I more or less quit drinking in my marriage where I was trying to repair my marriage in 2014 doesn't mean I'm an alcoholic or a drug addict, and frankly, it's offensive to me an invasion of privacy that Mr. Wade would want to publicize 4 or 5-year-old emails with my wife when we were together. He says I beat my children. I've never beaten my children. I'm a wonderful father. I don't hit. I don't believe in spankings. I've never beaten my children. He says in early October, after Amber Dewars posted about me, I went to sue Amber. No. I had my lawyer speak to her lawyer about a potential motion for contempt sanctions because it violated the initial restraining orders in our divorce. And that was what resulted in a more enhanced, stipulated joint order that kept us from disparaging each other to other third parties or encouraging people like Mr. Wade to post about each other online. He says, Mr. Wade says, he's known me for 15 years. I moved here in January 2008. So I've been here just a little over 10 years. I don't know what this 15 years is about, and I don't know ever meeting Mr. Wade. He says that on more than one occasions at a restaurant, I threw a hissy fit and made my wife cry. It's just not true. It just is absolutely not true. He says I committed adultery. It's none of his business, but I did not commit adultery. He says I banned from multiple occasions, including Bruciato. That's not what I was told, and I had a good relationship with Brendan McGill, the owner, for a long time. I've been into San Carlos many times recently. I've never been told that I was unwelcome at San Carlos. He says I have a history of drunk driving. I've never had a drunk driving incident. I've never had a drug or alcohol-related criminal conviction or charge. I've never been charged with drunk driving or public drunkenness or possession of drugs or anything else illegal with respect to alcohol. He said I've been in 7 collisions. It's not true. I did have some fender benders. I don't think it's 7. They were really minor. It was like I scratched a guy's car at the gym parking lot and then paid for it voluntarily out of pocket and left my information. He said I filed a false claim with Geico Insurance. That's not true, and that's all just hearsay. He said I threatened to sue everyone and anyone. No, I didn't. He said I threatened to shoot this Tyler Heineman character. No, I didn't. He said I tried to send him a wild goose chase in Port Orchard. That's not true. Over the course of this legal dispute erupting, I examined the applicable statutes and legal research and learned that the anti-harassment statute and the anti-cyberstalking statutes are created specifically for this legal scenario, and they seem like the more appropriate way to seek redress, just like having my lawyer contact my former spouse's lawyer in the context of our divorce to propose an enhanced mutual restraining order based on the conduct of posting about me online seemed like the appropriate way to pursue legal redress. Mr. Wade says I was going to sodomize his mother. I didn't say that. In fact, he tried to argue that to the court on October 22nd. They rejected him. He accused me of financial abuse of my wife. This is just absurd. In the first half of 2017, paid my wife, well, in the year 2017, because I just did my taxes, I gave my wife $175,000 in spousal maintenance and child support. He said I haven't paid child support or spousal maintenance this year. It's not true. And I just got my bill for preschool today for the first time. My wife gets, I pay all the expenses. I pay $4,200 for the mortgage on the house. I get $7,500 a month in cash every month. So $11,500. I pay all of the health care and all the kids' expenses. I pay about $15,000 a month for a total of about $180,000 a year. I don't commit financial abuse. That's just absurd. The green canopy stock is part of our overall property division that is the subject of our divorce and going to trial. There's no shares to transfer. The judge is going to make a division of assets in our pending divorce, which is why, frankly, Mr. Wade should be leaving me alone and us alone to go through our divorce and let our divorce court govern our interactions with each other. I've never used the internet to obtain sex for money, in exchange for money. The post that he showed over there doesn't show anything except that I was on that website after I separated from my wife. And in fact, I was investigating the website for a class action because of the expiration of credits under Washington's gift certificate statute. I had a client that I was exploring that for. I never groped a girl at the Winslow 122 or in front of a husband. I don't grope women. My wife absolutely was arrested for domestic violence on the morning of January 10th, 2017. It's really hard for a woman to be found by officers responding to a 911 call. It's statistically uncommon, perhaps not hard, for the woman to be found as the primary aggressor. All everyone has to do is to read that police report. It was 5 in the morning. I was getting the kids ready for school. My former spouse was still drunk from the night before. And she got angry and smashed a glass over my head, and I responded by calling the police. I've been really a model citizen for a long time. I just take care of my kids. I just work my job. My former spouse hates me because that happens in divorce. And Mr. Wade is attempting to, I guess, champion her interest for a sense of its own significance. I think if there's anything that could be taken away from Mr. Wade's testimonial presentation is that he is a man on a mission with respect to a fair number of people. I'm one, Bill Nelson is one, but his chosen method is harassment and public attacks and public shaming. And I'll leave my testimony at that because I want to focus on this super important legal issue.
Okay, well, before we get to the legal argument, any response, any rebuttal response to just the information that was additionally provided by Mr. Dewar?
Yes, Your Honor. He perjured himself several times there.
Specifically
in stating that he doesn't hurt his children and doesn't abuse his spouse. His own father called Child Protective Services on him when she mysteriously broke her arm. Mr. Dewar threatened to sue her. Mr. Dewar did threaten to sue his wife for harassment for posting his own words to her Facebook page. He also threatened to sue Ms. Shannon Evans for harassment, as well as threatening to sue myself. He threatened to sue Brendan McGill to either convince him to, fire me from my job or to not testify on my behalf if need be. Mr. Dewar uses legal threat as a means of controlling information about him. I see that as a rich, powerful attorney in this island and a man who has his name on his own law office door, that he becomes a limited public figure in this respect, and the fact that he messages constantly every single woman in the Seattle metropolitan area trying to obtain sex or dates, and has done so since before his wife filed for divorce. He's lying when he says he has not tried to obtain sex via the Seeking Arrangements website. He's contacted several women I know, including a coworker on that website as well. So as a witness, his testimony is full of perjury and should be treated as such.
All right, thank you.
Yeah.
All right, Mr. Dewars, I'll hear a legal argument from you.
The statutes that are involved in this petition are tricky until one drills down into the case law and interpreting them. And that is because it is anecdotally common when you're thinking about the exceptions to First Amendment protected speech to think only about defamation. And of course that's only one of a list of types of speech excluded from First Amendment protections. Others include fighting words. Others include speech that is integral to criminal conduct. And that's the exception here, not just because I say so, but because it's the exception relied upon by all of the federal courts examining the issue and all the state courts of Washington examining this issue. It's also reflected in the Washington Attorney General's briefing in response to Mr. Rynearson's remanded action for an injunction invalidating that statute.
What is the criminal conduct here?
So, all of the cases say, and I'll direct you to the citations, that when speech that is otherwise protected, which is say it's truthful speech, John Dewars had an affair, is combined with the intent to harass as opposed to the intent to exercise what would be First Amendment protected social commentary. And the actus reus, or conduct piece of carrying out harassing communications to the petitioner or third parties using new technologies like the internet, including Facebook pages. This speech, combined with that conduct, is found to no longer be pure speech protected by the First Amendment, but rather speech that is integral to the criminal conduct, and therefore loses First Amendment protection. So when Your Honor looks at the language of the cyberstalking statute here in Washington, which mirrors the federal cyberstalking statute, as well as I think the express language of the harassment statute, the recitals and definitions exclude First Amendment protected speech. But actually they don't exclude First Amendment protected speech. They say that these statutes don't criminalize First Amendment protected speech. And it's a very different sentiment from a legal standpoint, because when you look at the case law, one way to interpret what they're really saying is when the speech is coupled with conduct that meets the mens rea and actus rea elements of these two statutes, then the speech is no longer First Amendment protected speech. And that's what the court found in the Rynearson versus Moriwaki vacating order. That the Kitsap Superior Court did not say that the analysis I just gave Your Honor is not the appropriate analysis. The Kitsap Superior Court said I looked at the context and the content of the speech, which was mainly debating political issues, local political issues, and concluded by preponderance of the evidence that it was more social commentary that would be protected by the First Amendment than it was motivated by a desire to harass. And that preponderance of the evidence analysis is what all the case law asks the court to go into. So essentially, if Your Honor finds that by preponderance of the evidence, whether Mr. Wade calls his site a news website or a social commentary website, which are pretextual arguments that have been rejected in other cases, if Your Honor makes a preponderance of the evidence finding that the purpose of the speech is more to harass, torment, or publicly embarrass, then an order can issue restraining that speech. And the cases that articulate it best, we'll start with Washington. Those cases begin their discussion on page 6 of the supplemental briefing. In guardianship of Jansen.
Isn't that an unpublished case?
Many of these cases are unpublished, Your Honor, because this issue doesn't reach the appellate decisional level.
Isn't that an appellate case that's unpublished? Guardianship of Jansen?
Well, I think it's because they're so factually specific, Your Honor. I mean, there are a number of published cases.
Can't I not consider it when it's unpublished?
I don't know that that's true anymore, Your Honor.
All right, why don't you go ahead?
Starting with the analytical principle that when applying either the federal or the state cyberstalking statutes or the anti-harassment statutes, the notion is that the speech that gets combined with the conduct stops being First Amendment protected speech when it's combined with the conduct that meets the elements of either cyberstalking or harassment.
What's the conduct involved? Can you explain to me what isn't speech? Factually?
Sure. In the Makovich case...
No, I mean in this case. In your factual scenario.
The dissemination of deliberately embarrassing information, not for the purpose of engaging in social commentary, but for the purpose of, to use the language of the statute, seriously alarming, annoying, harassing, or causing detriment to such a person.
So is it always harassment to disseminate information that's true that could embarrass the person who is the subject of that?
Great question, and that's why these cases are so tricky. The answer is no, it's not always harassment. The court has to find the requisite intent for harassment by conducting a review of the context and evidence that would seem to reveal intent, such as Mr. Wade's communications to me that his desire in all this is to ruin my life and take away my livelihood.
If a writer for the New York Times has a desire to take down people who have gotten away with sexual misconduct for a long period of time and has a personal desire to do that, and it motivates him to do the research and write the article, is it harassment to write an article about somebody that contains true information because he wants to hurt that person?
It depends on the elements in the particular state. The only elements that
I'm just saying if that hypothesis were here, would that, in the state of Washington, would that then be harassment?
That would be a totality of the circumstances analysis that the court would have to conduct if it was going to enforce the Washington anti-harassment or cyber-stalking statutes. And it would, the court would be asked by the existing case law or the controlling case law to look at evidence revealing the intent of the writer, the extent to which the topic reached into public concern, the methods used, such as whether or not they're Facebook pages or an article in the New York Times or an academic journal or picketing. The medium used by the person disseminating information is part of the analysis. It's treated on page 10 of the supplemental briefing, where the Washington Court of Appeals in the Kincaid versus Priest case says the key to the analysis is whether the purpose of the challenged speech is to harass the victim or serve a lawful purpose. Similarly,
Isn't free speech a lawful purpose?
until it becomes speech whose intent is to harass, at which point it becomes combined with the conduct elements of the anti-harassment statutes and cyber-stalking statutes and falls outside the category of protected free speech. That's how the courts conduct that analysis. And I just want to make sure that you have the sites that support that. For instance, on page 9 in the Pets case, which was not cyber-stalking, but posting flyers about a man's ex-wife, accusing her of adultery. Sure, that was free speech, but the conduct fit the anti-harassment statute because it was combined with the requisite intent or mens rea and the adequate conduct to suit the definition of harassment under the Washington statute. Similarly, in Guthrie, a former wife was restrained from contacting her soon-to-be ex-husband's military colleagues and the people who ran the VA hospital and other organizations that he received services from. He obtained a temporary restraining order and permanent injunction. She came back, much like Mr. Wade does, and says, no, there's a lawful purpose in exhibiting free speech because I'm trying to prevent fraud. And the court concluded by preponderance of the evidence after an examination of the content, context, and evidence of the speaker's purpose that the more likely desire was to harass her husband, and an order issued. The order was modified slightly on appeal, but only to say that there would be some circumstances, if non-harassing, that she could contact the military because she might be receiving, for instance, future military spouse benefits from the military. That Jansen court, the restraining party is making posts to websites that are derogatory. The court takes pains to say that the posts are both harassing and defamatory. So, actually, if I could, Your Honor, on page 7, first full paragraph at the end, the Jansen is taking notes that the cyber-stalking petition prohibits publication of harassing or defamatory speech. I think that quote, and we can go back and look at the case and expand on it, but the point is that that harassing speech, you asked me the question, is it always harassment if this New York Writer Times produces a piece exposing child molesters? Is that always harassment? that would not be First Amendment protected? And the answer is no, it wouldn't always be. But if a court looked at both the intent of that writer and the effects to see if they fit the plain language definition of the harassing statute, it could be the subject of a criminal prosecution for harassment or a restraining order for harassment, and the type of media used and public concern associated with it would be part of the analysis. So this is a great quote highlighting that once the speech is harassing or defamatory, that is disjunctive, suddenly that speech is no longer a constitutionally protected right. It falls off the list of types of speech that would operate as a complete defense to a harassment or a cyberstalking claim. The purpose of these statutes, Your Honor, is to create a remedy for a kind of harassment that arose with the ubiquitousness of the internet being established, where defamation wasn't a viable or effective remedy, but the new technologies were being used to harm people in a way that disrupts lives. So if you have a chance to look at the Attorney General's opposition brief in analyzing likelihood of Mr. Rynearson's chance at merits on success, the Attorney General's office notes a lot of the social policy behind creating this cyberstalking statute because of what people are doing with the internet right now, like what Mr. Wade is doing, and points out that the facial constitutionality of the statute exists because it doesn't restrain pure speech. It restrains speech only that has been combined with this conduct where the mens rea and actus rea are sufficiently present to meet the definitions, plain language definitions, cyberstalking and harassment. The same, and just so you know, if you want to go back to the sort of the provenance of that analysis, it's known as the Given Doctrine. And the idea is that speech isn't speech anymore when it becomes legally operative. Sort of like hearsay isn't hearsay when it's when you're talking about out-of-court statements that would have a legally operative transactional effect, like forming a contract. Under Gibney, they point out that in addition to defamation, fighting words, obscenity, other kinds of unprotected speech, the speech that would otherwise be protected when combined with the conduct becomes criminally operative in nature. And the three big cases that came out of that involved where ex-boyfriends posted sexually explicit material about their ex-girlfriends on the internet. It would normally be First Amendment protected speech, but the court found that when the speech became combined with conduct, it became the appropriate subject of criminal prosecution or civil restraining orders such as the one we're looking for here today. And the Facebook, the sexually explicit, the posting of sexually explicit information is an easy fact pattern. It's easy to get behind that. But other courts have extended it beyond. That's why at the federal level, you have the Gibney doctrine being applied by the Matuzevich case, where the defendant posted websites just like Mr. Wade has posted and sent communications to the children's school and the wife's college, just like Mr. Wade has done. And they accused the ex-wife of sexually abusing the couple's children. This gets back to your question of, is it always harassment? No, in fact, one of the defenses raised in that case was that the husband's sister said, I'm an aunt and I'm just concerned about the welfare of my kids. It's rather like Mr. Wade saying, this is a news page and a matter of public concern. The courts tend to find it pretextual when there's other indicia of an intent to harass there, such as Mr. Wade saying, this is going to be fun, I'm here to destroy your life, not to warn people. So the claim that it was that in Matuzevich it was really just being concerned about child welfare was disregarded on a preponderance of the basis standard by the court, and that cyberstalking federal claims are allowed to go forward under the Gibney doctrine, combining speech with conduct. Similarly, the case in Washington that's most like ours is Beanie, I think, which was cited by the Attorney General's office and speaks extensively about how the pure speech no longer becomes First Amendment protected speech when combined with conduct that makes it either harassment or cyberstalking under Washington statute. And in that case, the speech in question was that Beanie was a friend of a former spouse, just like Mr. Wade is a friend of a former spouse of mine. And the former spouse was a male who actually gone to jail. And the friend, Beanie, created this webpage about the wife.
I'm familiar with the Beanie case. I did read it.
Okay.
What
it
are
was the same kind of stuff. It was, she's an alcoholic. She has drunken fits of rage. And he was required to take all of that down. And the taking of it down is considered, under the cases analyzing this, not to be a violation of First Amendment principles, because the order to take down Facebook pages or take down this website in the Jansen case are not orders that specify content restrictions. The whole point that the cases are reaching at the state and federal level in the context of all this jurisprudence is that it's just saying stop using these new instrumentalities or these styles of disseminating it because it constitutes harassment. It doesn't, so an order in this case could never say Houston Wade cannot say that John is a drunk. Houston Wade can say that John is drunk. If he says something more factually concrete than that, then maybe a defamation claim which the court can enjoin under well-settled principles. But the order does and should continue to say Houston Wade cannot continue to post about John DeWars online or knowingly reach out to John DeWars' professional colleagues for purposes of harassing him.
So that's what you're asking for. You're asking for the court to indicate that Mr. Wade cannot continue to post about John DeWars online in any way.
Well, that language, as you've articulated it, satisfies all the case law. That's what we saw in the Sudovich case. It's what we saw in the Jansen case. It's what we saw in the Bean case. If Your Honor is afraid of restrictions, you could take the additional step of saying for purposes of harassment. So if the two pieces of language, the main pieces were Houston Wade will not post online about John DeWars for purposes of harassment, or he will not communicate, he will not knowingly or willfully communicate with DeWars' professional colleagues, family members, or social connections for purposes of harassment, that would be a cautionary step. The reason I don't want Your Honor to put that restriction on the online posting is that it's going to invite us to be here a lot, because Mr. Wade is going to step by step.
Okay, well, what I'm trying to determine is what are you asking for in your request for this protection order? You're asking for him, are you asking for all the language that was specified in the temporary order?
No, I think that if we can keep the language regarding...
It's yes or no. So you proposed, as I understand it, this attachment at the time of the temporary order that provided specific language that the court incorporated in the temporary order. Is that correct?
I did, Your Honor.
And are you asking for the same language?
Well, some of it has been mooted, is my point. That's why I hesitated. So if we're being judicious about what language...
What do you mean mooted?
So, for instance, posts on Twitter and the Bainbridge Island Bad List have been taken down.
But isn't your intent to prevent Mr. Wade from posting anything on the Bainbridge Island Bad List and Facebook going forward?
Yes, Your Honor.
And that's what you're asking for?
I wanted to answer your question accurately.
Okay.
So the exact language, I mean, I would like...
I don't want to get into specifics. It's just,
okay.
Are you asking for generally this language?
Yeah, that's right.
Okay. All right. We're at 3 o'clock. I'd like to hear from Mr. Wade if you'd like to provide some argument, and then I want to have time to take a look at the exhibits. Mr. Wade, do you have any argument?
I do, Your Honor. In the exhibits I gave over underneath my posts to my own personal page, there are several women who mentioned that Mr. DeWars contacted them while he was married. I'd also like to point out that my original post, I did not use his name on my personal page. On the Bainbridge Island Bad List, the report I wrote, was factual and not defamatory, even though Mr. DeWars has threatened defamation lawsuit repeatedly. And his only recourse from that point forward was to seek harassment after he harassed me with frivolous legal threats and others. Any escalation in this was a result of those frivolous legal actions. When I wrote Mr. DeWars' colleagues and partner, I stated factually what was written in the Bainbridge Island bad list, and I said the solution is to get Mr. DeWars into rehab, which is true. He needs to stop drinking. Much of our communication was while he was obviously intoxicated. And he has, in fact, been kicked out of San Carlos. He has, in fact, been kicked out of Brusciato. He's not allowed in either of those locations because of his belligerent drinking. It is well known on the island amongst the restaurant community about Mr. DeWars' actions while intoxicated. If this were to come to a harassment trial, I can provide many, many, many witnesses who will testify to that effect. This Bainbridge Island bad list might not be the New York Times, might not be the Washington Post, but it is relevant to our community to protect people and make them aware of abusers and sexual predators amongst us. And these men don't stop. They will continue to do what they do, regardless of court findings, regardless of witness testimony, regardless of any of that. And Mr. DeWars will seek to try and temper that as much as he can via legal threat, because that's his best avenue. He is a lawyer. But legal threat does not change the truth. And inside the evidence I provided, he admits to abuse, he admits to alcoholism, he admits to chemical dependencies, drug use. This has not changed. I'm sure that after his domestic violence conviction in 2014, when he had to go to counseling, it may have been the first time in his adult life he had ever been sober, such as why the tone in his emails are so much different than any messages he sent before or after. The intent of the Bainbridge Island bad list is not to harass specifically Mr. DeWars, but to make the island aware that in our community there are men who hurt children and other women, and Mr. DeWars is among them. So this hearing for harassment finding is it's silly, because he's the one who keeps contacting me and threatening me with legal action, threatening my mom, threatening whoever he can. And for him to state that he did not threaten my mom is ridiculous, because you have the documents that I submitted where he sends me her address repeatedly, describes her home in detail down to the wreath on her door, and then says he's on his way to, quote, butt sex her. So Mr. DeWars has perjured himself repeatedly in his testimony, and that alone is a violation of legal ethics. I think it is pertinent that officers of the court, lawyers, licensed lawyers in our community, in our state, should abide by the law above all else, and that informing his partners of his illegal activities and his actions and his repeated frivolous legal threats is in fact pertinent, that his partners should know.
All right, thank you.
Thank you.
All right, I'm going to take a recess, and we'll come back at 3:30, and the parties can just follow the directions of the officer related to the maintaining on our small premises here.
All right. Court at recess. All rise. Court will reconvene.
All right, please be seated. All right, I have reviewed the testimony and exhibits in this case and the case law that is relevant here. And I'm going to go through and discuss what the court is finding and the reason for the ruling as best I can. So in this case, this is a request for an unlawful harassment protection order as well as a stalking protection order. The prior judge found that there was enough evidence to issue a temporary order and did so, prohibiting Mr. Wade from publishing on his pages information about Mr. Dewars. Unlawful harassment is defined as a knowing and willful course of conduct directed at a specific person which seriously alarms, annoys, harasses, or is detrimental to such person and which serves no legitimate or lawful purpose. The course of conduct shall be such as which to cause a reasonable person to suffer substantial emotional distress and shall actually cause substantial emotional distress. And the petitioner has to prove this by a preponderance of the evidence. The definitions in the harassment statute are in 10-14-020. It says course of conduct means a pattern of conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose. Course of conduct includes, in addition to, but any other form of communication, contact, or conduct, the sending of electronic communication, but does not include constitutionally protected free speech. Constitutionally protected activity is not included within the meaning of course of conduct. So the issue here, in looking at the stalking protection order, stalking in the findings in 7292.010, the findings indicate that protection can be accomplished without infringing on constitutionally protected activity. 792.01 requires that any stalking conduct also serves no lawful purpose. And so the issue here really is there a legitimate or lawful purpose for this behavior? I think that Mr. Dewars has established that the respondent intends to cause harm to his career and have him perhaps be punished by the Bar Association or by his partners and his law firm, and that he intends to provide a public airing of Mr. Dewars' wrongdoing. And I think that's very clear from the information that's in the record that he has a dual intent, both personal and, as he indicated, to protect others from people who he considers to be abusive or harmful to women and children. So the legitimate or lawful purpose, as referenced by the statute, would include constitutionally protected free speech. And free speech would be a legitimate or lawful purpose. Of course, there are certain narrow, limited classes that are unprotected by free speech, and they are obscenity, defamation, fraud, incitement, true threats, speech integral to criminal conduct. Mr. Dewars tried to argue that there was proof here that there was incitement or true threats and also speech integral to criminal conduct, and the court finds that there really is not that. There's nothing about Mr. Wade's publications that indicate that he wants people to try to injure Mr. Dewars or that to do any sort of illegal acts, but just that he wants them to try to stay away from Mr. Dewars. Additionally, the proof really would lie in Mr. Dewars in trying to prove that this falls within the defamation category. And if it was indeed defamatory speech, then it would not have that constitutional protection. I don't agree with Mr. Dewars' assessment of the case law that if Mr. Wade had an intent to harm him, then that overrides the constitutional protection of speech, and I don't think that's what the case law said. I read many of the cases that were cited by Mr. Dewars, even though some of them were not published opinions. I did consult the rule. It does indicate that unpublished opinions of the court on or after March 1st, 2013 may be cited as non-binding authorities and may be accorded such persuasive value as the court deems appropriate. So it's not totally inappropriate for the court to review them, but they don't have the kind of binding authority that some of the other cases do, and I'm going to discuss some of those here. So the cases that the court finds most instructive in this particular case is State versus Noah. In Noah, the respondent picketed outside on the sidewalk in front of a therapist's office, with signs that indicated voodoo therapy practiced here, Dr. Kaloff, you windbag, psychotherapist, big bucks for therapy, spreading child abuse hysteria, and David Kaloff, voice of hatred and revenge. In that case, Mr. Noah did not even have a connection to this particular therapist. In fact, his daughter was treated by a totally different therapist in the office. But the court found that the picketing behavior could not serve as the basis of an anti-harassment protection order because it involved free speech, which is a lawful purpose. And it indicates that speech on the, or by application, the speech on the internet is our modern day picketing. And that's what the court found in the Rauch appeal in the Rynearson case, and in fact overruled a prior order of mine indicating that speech on the internet is much like picketing, and it's a public forum where people are able to communicate with one another and post information. U.S. v. Cassidy is also applicable here. That is 814 Federal Supplement 2nd 574 2011. In Cassidy, a former sect member used Twitter and a blog to comment on the sect and the sect leader. All but a few of the nearly 8,000 Twitter posts by the defendant related to the sect or the sect leader, and the federal court upheld the speech as protected speech and dismissed the indictment for stalking against him. The court in Cassidy reasoned that the First Amendment protects speech even when the subject or manner of expression is uncomfortable and challenges conventional standards of good taste. The U.S. Supreme Court has consistently classified emotionally distressing or outrageous speech as protected, especially when it touches on matters of public concern. And in this case, I would find that there is an intent to air this information because of public concern and trying to be protective and information sharing to people who could be at risk in the author's opinion. Speech cannot be restricted simply because it is upsetting or arouses contempt. The court very bluntly explained in Cassidy, Twitter and blogs are today's equivalent of a bulletin board that one is free to disregard. Here, the speech may be defamatory in nature. However, I don't find that that has been proven. The contents of the posts warn the public about Mr. Dewars and his criminal history, his use of alcohol, and his behavior in the community as an attorney. There are posts on the Facebook pages of Houston Wade and the Bainbridge Island Bad List. There is an email to Mr. Dewars' law firm at info@newmanlaw.com and a review post on Google Business. Mr. Dewars bears the burden of proof of proving by preponderance the evidence that there is no lawful or legitimate free speech purpose for the behavior. Defamatory content would have no lawful or legitimate purpose. Mr. Dewars did claim in his petition that the information presented is almost entirely false. For example, that he doesn't have criminal convictions, although when pressed, he does admit that he has convictions for domestic violence, hit and run, imprisonment of a minor. He denies being charged with obstructing, but Mr. Wade did present evidence that suggests that he has been at least charged with those offenses in other court. There is also, Mr. Wade also countered much of Mr. Dewars' testimony by presenting evidence that shows the basis of his knowledge and why it is that he says what he does. Some of it is lengthy and perhaps not as content very relevant to the concerns, but there are pieces of it that are relevant because it is the reason that Mr. Wade feels compelled to say that Mr. Dewars is abusive, that Mr. Dewars is a alcoholic, and that he has been in crashes for drunk driving, and that he has been on sites where there has been perhaps negotiations for sex. There was at least one document that was from a woman on Facebook that had a conversation with Mr. Wade where she explained and sent him a post of Mr. Dewars' profile on seeking arrangements. So while this behavior, the court may not, or this way of public shaming, the court may not agree with from a taste perspective, I think that it is constitutionally protected speech, and the court cannot issue the order that is asked for by Mr. Dewars. The case law indicates that to do so and to prevent him from having any speech related to Mr. Dewars is what is considered a prior restraint on speech, and it's prohibited from the First Amendment, by the First Amendment. And so the court is not able to grant such a request. I think that Mr. Dewars could have presented evidence and perhaps tried to meet his burden by perhaps presenting some criminal history record of his to show that he did not have the charges that Mr. Wade claims he does, or he could have presented affidavits or testimony that show that this is true fabrication. I don't find that the one-on-one conversations are part of the harassment scheme. I think that they often were initiated, or are almost always initiated by Mr. Dewars, and was a back and forth that was really mutual, and that it was not harassment but more of a disagreement. I also think that there is a public concern element in contacting his employer because he talks about criminal behavior in the community, which is admitted. He talks about other behavior that would be of public concern for a person who is an attorney, and follow up with the Bar Association. And to prohibit him from contacting his employer would be, even if the court were to find that there was harassment, will be well beyond the scope of what the court can do. The court cannot prohibit a person from having contact with third parties in the scheme of a harassment order. The court could prohibit the respondent from having contact with Mr. Dewars. But in this particular case, I'm not finding that there's a pattern of conduct where he's reaching out to Mr. Dewars and trying to harass him. I think that there's just a disagreement going on about the behavior of maintaining this board. So, and I would also disagree with some of the characterization of the case law. I have looked at the case, in particular the Beanie case, and I think what's distinct about some of the cases that are cited by Mr. Dewars is that sometimes they're on legal issues that don't relate exactly, but factually they are often cases where there is proof that there was actually defamatory conduct. And in Beanie, specifically in the facts, it talks about the, I'm going to pull the case up. In that case, Mr. Beanie was contacting the past employer alleging that I was a criminal, and he claimed that I was selling homes without a license, falsely representing myself, and not using my real name or going by many different aliases. And in the discussion as well, during the facts, it says Mr. Beanie admitted he had no knowledge whether or not these allegations were true. And that is the crux of what some of these cases are based on, is that there is enough basis to show that this was really reckless in the language that was being shared, and there was no basis of knowledge. And I just can't find that here. I think that at least in the case of Mr. Dewar's, Mr. Wade has a reason that he feels that this information is true and not defamatory, and he's sharing it. If there are particular statements that are incorrect, certainly Mr. Dewar's has the remedy of seeking a defamation suit, as he has alluded to, and he certainly can appeal the court's order here today within 30 days. But the order of the court is that the request for full order is denied, and the petition is dismissed. I signed the order. I'll have Officer Roach bring this to the parties for their signature, and we will get you copies. Is there anything further that we need to address?
No, thank you.